Alternative Dig Talk. Real issues, real talk.
Hey Ugandans, I'm Lieutenant Colonel Dewa Kiki, the Deputy Defense Spokesperson and actually the Deputy Spokesperson for the Uganda People's Defense Forces. I was hosted on Alternative Dig Talk. I encourage all Ugandans that this is the way to go. Always watch, participate, give your views and ask questions on Alternative Dig Talk. Dig Talk, the way to go.
You have got to get up pretty early to go do something. We are the Alternative Dig Talk. With our mobile studios, we are redefining TV presentation just as technology is setting the pace. We are blending our approach with fresh, perspectively designed breakfast show, The Mighty Drive, informative and entertainment show, exclusive and live interviews.
We President Museveni wadde juzi namulaba apima akawunga kilo 2 tasobola kalya nini bwaba alya kilo 5 oyannema okuliisa eggwanga ne bwe limundekera.
Njagala kwebaza the Alternative Dig Talk etuwadde kano ka Mighty Drive era n'abatuwuliriza bonna abali ku mikutu njagala basaba mugende mu maaso n'okuwuliriza.
All given to you just a click away on your phone, tablet, laptop and smart TVs as we are streaming live on our social media platforms, on the road and on the go. We are the Alternative Dig Talk.
Hey Ugandans, I'm Lieutenant Colonel Dewa Kiki, the Deputy Defense Spokesperson and actually the Deputy Spokesperson for the Uganda People's Defense Forces. I was hosted on Alternative Dig Talk. I encourage all Ugandans that this is the way to go. Always watch, participate, give your views and ask questions on Alternative Dig Talk. Dig Talk, the way to go.
Alternative Dig Talk. Real issues, real talk.
You have got to get up pretty early to go do something. We are the Alternative Dig Talk. With our mobile studios, we are redefining TV presentation just starts. Technology is setting the pace. We are blending our approach with fresh, perspectively designed breakfast show, The Mighty Drive, informative and entertainment show, exclusive and live interviews.
We President Museveni wadde juzi namulaba apima akawunga kilo 2 tasobola kalya nini bwaba alya kilo 5 oyannema okuliisa eggwanga ne bwe limundekera.
Njagala kwebaza the alternative digital etuwadde kano ka Mighty Drive era n'abatuwuliriza bonna abali ku mikutu njagala basaba mugendo mu maaso n'okuwuliriza.
All given to you just a click away on your phone, tablet, laptop, and smart TVs. As we are streaming live on our social media platforms, on the road and on the go. We are the Alternative TikTok.
The Alternative TikTok. Real issues, real talk.
Morning, our viewers. My name is Tumuhimbise. I'm given an opportunity to also come back to Professor George Wilson Kanyihamba to share a few things, but this time around is to discuss his latest. This gentleman never gets out of new things. There is this new publication, just a month or thereabout, 2 months or thereabout, ever since he launched his 31st book, and he found it so demanding that he comes up with another to challenging a presidential petition. But I should ask him to say hello to the viewers of the Mighty Drive and also the Alternative Digital. Prof, say hello to our viewers.
Hello, viewers of this wonderful system that we are using to communicate with you. Once again, I'm very, very delighted to be here, hosted by Norman and his team, to share some of my thoughts on governance and other issues. Thank you.
Thanks, Prof. Our viewers, we are on our Facebook page, The Alternative Uganda, and then YouTube. Minutes after the show is done, I'll also be there. The show is always uploaded into the YouTube channel. That's The Alternative Uganda. And also on Twitter, we are on Alternative Yuga. It's been a while, and this time around we shall be bringing Prof. Kanyeihamba in a series of shows to discuss his new book, Challenging a Presidential Election. Article 104 of the Uganda Constitution and the Presidential Elections Act 2005. Before we go deeper into this new publication, which is page 60, and he pledged reading through, so he's going to read the book himself, and you will not mind our speed, mind the wisdom that he's going to share. Before we go into the book, Prof, there is a battle now that is visible, and that's in regards to the parliamentary race. The friction, for lack of another word, is between herself, the lady, the Iron Lady, Right Honorable Rebecca Kadaga. In her words, she said she's being pushed away or out of the party by some party leaders. But also she, for me, what was key is about her address, where she said, in Lusoga, Basoga Vanangi, and fellow Ugandans, what's your take? Because she's contesting as an independent, no doubt, and that is today. Do you think she stands any chances?
I think that it was most unfortunate for her when she started challenging the NRM party nomination of Right Honorable Olanya for the first post-op speaker, for her to degenerate, if I can so her, in sectarianism of tribe and feminism. That was most unfortunate. I have known Rebecca Kadaga ever since we were both members of the Consultative Council or the embryo parliament before we made the 1995 Constitution. And she's a very principled, nationalistic woman of integrity. But it seems to me that the longer you stay in office, the more you forget your manners, and the more you even forget the principles which brought you there. When we first debated the 1995 Constitution in the Constituent Assembly, many of us hadn't thought about it seriously. But three very eminent delegates from the army, the late Serwanga Rwanga, Fusa, formerly Tinyefuza, and I believe the third one was Chiza Besije, even outside the Constituent Assembly, were of the slightly different view that whereas they supported enthusiastically the empowerment of women as an marginalized largest group in the country, this empowerment would be more beneficial if more women became leaders in government, in industry, continuously changing. So their view was that the first leaders who were elected after the 1995 Constitution should only be there for a period of 2 terms. And then others replace them every election. That way we would spread the idea of empowerment to the whole country. That really was their view. I'm not saying that all of us appreciated that view or shared it, but it is a view that had some common sense. Now, Kadaga was, and we were very delighted when she was first elected the Speaker of Parliament. She's been there for a long time. One of the reasons I am here is I am opposed to people staying in power longer than absolutely necessary, so that they give a chance to other Ugandans who are equally, if not more, equally qualified, so they can also have opportunity and the chance to have a shot at the governance of this country. No doubt that this Olanya has understudied Right Honorable Kadaga for over 20 years. He has chaired many sessions of parliament in her absence. At one time, she was gravely sick, and she even went abroad for treatment. And my understanding at that time, it could be having it rumor, there was an understanding in the NRM party that the last election, the 10th take 10th Parliament, Kadaga should be allowed to be the only candidate from the NRM to compete for the speakership. But that the next parliament, which is now, the 11th parliament, our deputy, Olanya, would be the flag bearer for the NRM party as speaker. And that rumor or story has never been refuted. And so I was not surprised when the NRM, in accordance with the spirit of the Constitution and that story, nominated Oranya to be the speaker for the 11th Parliament. And I think most Ugandans believe that he's a proper person and it is the right time for change. And for change, for me, I have been campaigning for change even 2 terms before that. So for me, I am sure that the forces of Museveni, the NRM, who have got a majority members in parliament, and who are going to form the next government, will succeed, and we say very nice goodbye to our sister, Rebecca Kadaga. That is my personal view. And therefore, I have never been partisan in determining which governs our country, but I point out as an elder that so and so would be qualified to do this. So and so would be qualified. Both of them, I must declare a personal interest, are friends of mine. When I launched my first book, a recent book, The Blessings and the Joy of Who You Are, I particularly identified Rebecca Kadaga, then Speaker of Parliament, to be the guest speaker, rather to be the guest of honor at the launch. And she gracefully came and said very complimentary words about me. When we were going to launch this one, where evolution of constitutional government and public law, in which you helped greatly to organize, I consulted the seniorest members of the government about the venue and also about the number of people who could attend the launch. And I also said, last time, I asked the Speaker of Parliament, Rebecca Kadaga, to preside over the proceeding. Can you suggest somebody? And very, very high officials in the government, not President Museveni, recommended, why don't you ask for a change, her deputy, since you are also very high up in that level, to see whether he would agree to preside. And I called Jacob Olanya, who was delighted that he would be very happy to be chief guest at the launch on the 26th of last month. He came, he kept his word, and he said wonderful words at the launch. But one thing he revealed, that he is an accommodating leader, that he takes into account the rights, contribution of the others. Not only did he acknowledge the little part I have played in governance in this country, but he recognized the other guests who represented the spectrum of Uganda echelons of rule, we had the former Prime Minister, Amama Mbabazi, at the launch. We had the leader of the Democratic Party, now. He was at the launch and on the panel. We had Professor Lumumba, the famous African legal guru. He flew all the way from Kenya to launch the book. We had the leader, the deputy leader of NUP, the National Party of Chaglanyi. She was president, she spoke. We had representative of the Conservative Party. They didn't identify themselves, but they were there. I had invited, and he had agreed to come, Ofono Pondo, the spokesperson of the NRM. And he had talked to me, and he says he's looking forward to it. I don't know what prevented him from coming. I discussed the whole program with the Prime Minister, who recommended that we should not invite more than 200 people. In the end, those who invited came, they brought even others, and the number was excessive, but the room was so big that we didn't break the coronavirus rules. So finally, because I know you are going to ask me some other questions, my view is that the NRM has had two shocks. The last general elections, that is of this year, were not good for the NRM. They lost most of their ministers and all their representatives in the Buganda region, the central region. The Buganda representatives met recently, and they have become almost sectarian. They are saying the NRM took away their things, they are now being working that. The Bachiga have got a saying, and I'm going to start on presidential petition elections with one of the sayings, or a few sayings, that if the red ants, they bite very viciously, if they are on their way immigrating to somewhere else, don't disturb them by putting a small branch of the tree in their march. They'll become mad and start biting you. Buganda has been a sleeping giant, quiet, lawful, and obedient, particularly to the NRM rule. But something put a small branch in its march, and that was the 1921 general election. Things will never be the same in Uganda. They are now resumed their legitimate claims, including the status of federal things that the central government took away. Even if it wasn't President Museveni, they blame the central government for not returning them. And the politics will never be the same. I don't know how the cards are being played out. But then I am not surprised that Rebecca Kadaga, whom I used to call my personal lawyer, has put a branch in this peaceful march of the Basoga by claiming sectarianism and saying, please, you have a number of people in the parliament, in the 11th parliament, who vote for me against the official candidate of the party which originally sponsored her. That really is a recipe for unclear waters of peaceful politics in the next 5 years. And in order to avoid them, the NRM must show that they are in charge, peaceful charge of the affairs of this nation. Nowhere in the world, as far as I know, especially in democratic countries, can you elect a speaker who belongs to the opposition. You cannot elect a speaker who is not who is opposed to the party of the president and the cabinet.
And
so
on a ticket that enabled her be an MOP in the first place.
That's the one we can forget, you can change. But whether we like it or not, the NRM will be in power from tomorrow. I think they are separating tomorrow for the next 5 years. And we'll have peace in this country. We don't want any changes. The person who was agitating for change has recently become quiet. I don't know what is happening. Chagulani. He even does not. I supported his election, but he seems to have forgotten that I support him. So he's become a known enforcement agency. And the only challenge I see against Museveni's government, which I'm going to argue in my book, that it may continue, but certainly Museveni, time is up. And he should tell us himself. He's got now the ability and all the ample chances to tell Ugandans that this is his last term. That's what I'm going to be campaigning for the rest of these days which God, or these years, which God, I'm sure, is going to give me until he achieves his objective for the peaceful transfer of power in this country.
Okay, those are the words of Professor Wilson Kanyihamba, and we're sharing with him a few insights about the breaking stories and headlines in town, and also in particular Uganda as a whole. I want to ask that we now got onto our new book, and with the title Challenging a Presidential Election, Article 104 of the Uganda Constitution and the Presidential Elections Act 2005 by Professor Dr. George Wilson Kanyihamba. I am going to just read the introduction, and then I will ask him to proceed with the reading so that people can understand. We are asking lawyers in town and judges and also citizens who believe in democracy and good governance to pay attention, because the old man is going to read the book so that he makes it so simple for every viewer to understand. But I will offer myself to read the introduction, and this is how it goes. In this publication, we emphasize that there can never be any alternative for Ugandans other than to restore their constitution of 1995, voting in brand new, patriotic and principled leaders. Voting in brand new, patriotic and principled leaders. It's no longer a matter of debate that the NRM party today exists and only thrives on the evils of corruption, abuse of office, and is indifferent to the aspirations and welfare of the people of Uganda. A ruler or government which is indifferent to democracy, rule of law, constitutionalism, and human rights, fortifies does not deserve to stay in power in any country. This monograph is suitable for every Ugandan, whether legally qualified or not, and it has been heavily subsidized to be afforded by everyone. That is why it is priced only 20,000 shillings. So that everyone, whether old or young, who believes that this country should be governed well finds time to read and understand. And if unable to read, have it read for them. No judge or lawyer should ever be without a copy of this publication. Copies of this book can be obtained by contacting the author / publisher on 0752 47 99 65 or the Alternative Digitalk Uganda on 0783 04 7785 or 0702 9076. Prof, let's begin with your first chapter in this wonderful book under a chapter title, The Supreme Court is to inquire into and give findings and not hear or deliver judgment. Shall we proceed?
Forgive me, Norman, if I make a few brief comments on the origin of this book. And it took me only a week to compile the contents of this book and publish it. And the people who have sponsored it, you will be very surprised. But who would be surprised most would be the NRM leadership. I want to reveal them, but I have not spent even 1 shilling of mine to have this booklet published. It was on demand by their principled men and women of integrity who said, ever since the 2006 petition, Chiza BCJ versus Museveni and the Electoral Commission, you have been a single voice complaining that the Supreme Court has either deliberately or otherwise avoided the Constitution, the articles of the 1995 Constitution, and yet this is the same Constitution that both Professor Lumumba and Dr. Miriam Matembe said because of its contents and those who made it, it has been held as the best constitution in the world, and certainly by President Kaguta Yoweri Museveni has held it as the best constitution Ugandans have ever made, and he will go in the bush once more if anybody ever interferes with it. He was the chief guest when it was promulgated in his presence with the late and much lamented James Wakapubulo, who was the chairman of the Constituent Assembly, in the chair. You rightly pointed out the title of this paragraph, rather of Article 104.
Yeah.
I forgot my glasses.
Oh, someone.
Betty, where are my glasses? Betty. Me and everything. She's already produced them. I need glasses at my age. But these are reading glasses to read.
We're on page 5. If I could give you this.
Page 5.
You can have this.
Why not mine? Yours is the same as mine.
Yes.
Now, I thought we will have some little introduction.
Yeah.
So the book has been sponsored, not by me, but by politicians of goodwill, who, one or two, will admit they have. But if I revealed all of them, the others would deny, because of their sensitive positions in the government and in the country. So I will not reveal whether they are religious or otherwise. But I wanted us to remember, with the grace, the soul of the late Archbishop of Kampala, Luanga. Before he died, I had communicated with him on several occasions by phone. Then I formally invited him to the launch of this book on the 26th of March, was it?
Yeah.
And he had agreed to come. I had also invited the Archbishop of Uganda, Kazinda, who for some reason did not respond to my letter. I had also invited the Mufti of Uganda, Mubazi, because most Ugandans who know me know that I am non-sectarian, whether religious, tribal, or otherwise. And I love all my Ugandans, regardless of where they come from. That's why I have started this discussion with ticking off my good friend Rebecca Kadaga for raising the ugly head of sectarianism. At that meeting on the 26th, you were there. It was not only Olanya who came, Mbabazi came, Matembe came, Amanya Mushega gave the vote of thanks. Other people from NRM spoke lovingly. And I think it is summarized by what Mao said, the leader of the Democratic Party and the former presidential candidate. He said, Professor, you are in your hero chair. But the reason we came here is your wisdom. You are like a shining, inspiring source of authority in this country. And then Honorable Matembe, the militant feminine fighter, said, but you people, we didn't come here because of this book of Kanyeihamba. He's written many books, 31. We all came here because we love him. That was repeated by my former cabinet colleague and the former Minister of Agriculture, Victoria Secretary. To imagine, and this was eventually Olanya, to imagine that my opponents in ODP, UPC, NUPE, and opponents of Museveni, whom is my president, can gather here together in the critical period of the epidemic virus. And then those invited exceeded the number. And a human activist, a prince from the Ashanti of Ghana, comes all the way, flies, when he hears that Kanyehamba's latest publication is to be launched at his own cost. Is absolutely wonderful in this world. Those was our perspective, and the NRM candidate for speakership of the 11th Parliament. I felt humbled. I felt tears wanting to come. It was a very, very humiliating and humble experience. A leader who has no humility, but who started with humility. A leader who has no compassion. But Museveni still has compassion. So that's one I can't blame him. But the leader who says, I am no servant of anybody, but I have my own program. That leader, he should retire without any question. Secondly, President Museveni recently said that the police are corrupt, that many ministers in his cabinet are corrupt. His former Chief Justice and the Chief Justice Katulebe commissioned me to investigate and discover what judges and judicial officers were corrupt, incompetent, or abusing office, in that order. It was supposed to be top secret, confidential. Otherwise, those I named would be at my throat. But he deliberately leaked the information so that anybody, I named the 7 judges, 4 magistrates, and they all knew. Then, when he himself named judges who were corrupt, including one notorious one, personally and in the press, and he invited the Judicial Service Commission to investigate that judge and remove him from office. The press was very, very excited and listed the name. Not only that, that encouraged me to send my report, which he had held back, to the chairman of the Judicial Service Commission himself to handle the matter. He acknowledged the receipt of the report. I was interviewed by the Judicial Service Commission on a number of those judges. I remember among those I named, she would not mind for me to name her now. I named her not for corruption, but people had told me she was not doing the job properly because of limited qualifications. And that was Justice Monda. She used to call me my good friend. But I don't respect wrongdoing even among my friends. So that's why I named her. But later, she even wrote to me a letter thanking me. And she was one of those I sent this publication. She remains my friend. But she's innocent of corruption. And if she has got limited qualifications, it's not her fault. You remember she's one of those who complained against the Chief Justice, who deliberately kept her out of a panel that I think discussed age limit, I can't remember. So she's a good judge. But if you are good and you step on mud, I must tell you that you have that and you are shrewd. That is not because I hate you. I have always advised Museveni on a number of issues. And the Bachiga have a saying that it is he who loves you that I advise on the danger of what you are or you are not doing. I am a pure Africanist. At that launch, one of the commentators said, Kanyihamba, you have based many of your views on Western civilization and the writings of Europeans. That may be true. But he forgot to say that in my own community, I am known as a native historian. There is a video of Kanyeihamba talking about the history of the Bachiga and the Banyakigezi. If you read my book, The Blessing and the Joy, it is about that. Normally you will forgive me. This is a wrong introduction. But I think it is very important because you brought about the very important term governance, and we are in a crisis today, not of our own making, but because our political leaders have either let us down or have not done what they ought to have done and done what they are prohibited from doing. That's why I became emotional in this morning's remarks. But I want you to tell you that now this booklet, I have sent every judge of the Supreme Court and of the Court of Appeal a copy. The registrars of the two courts rang me last week, and they say he has received 10 copies for the Supreme Court, and he will distribute them to the members of the court. Then that one of the Court of Appeal also rang me. He has received these 10. Never again will the judges misinterpret the Constitution. Never again will lawyers mislead their clients or the petitioner and the respondents because each should get a copy of the Kanyeihamba little book called Challenging a Presidential Election. No Ugandans who can afford 20,000 shillings or whose relatives or son can afford to read for him should ever say, for me, I am ignorant because I have done the job publicizing, challenging presidential election, which is part of the constitution, which the Electoral Commission and the government of Uganda should have done 20 years ago when we enacted and promulgated the 1995 constitution. Because there is an obligation for the government to publicize and translate the constitution into our local languages so that every Ugandan, who, whether he reads or not, can understand. The Museveni government, who said this is the best constitution Ugandans have ever made, has failed to do that.
Prof, I will ask that we break shortly for a minute and come back, and then we are beginning.
Then I begin to read the book.
Yeah, sure.
And I will not,
on page 5.
And I promise I will not divert again.
Okay, sir. Our viewers, we're coming back shortly. We are still on the Alternative Digitalk, streaming live on our Facebook page, The Alternative Uganda, and also later on in the minutes to come, it's going to be uploaded on our YouTube channel. That's The Alternative Uganda, and we're on Twitter, Alternative Yuga. We are still with Professor Wilson Kanyihamba on the Mighty Drive. He's going to take us through a series of reading this latest publication. Don't go away. Coming back shortly.
Alternative Dig Talk. Real issues, real talk.
Hey Ugandans, I'm Lieutenant Colonel Dewa Kiki, the Deputy Defense Spokesperson, and actually the Deputy Spokesperson for the Uganda People's Defense Forces. I was hosted on Alternative Digitalk. I encourage all Ugandans that this is the way to go. Always watch, participate, give your views, and ask questions on Alternative Digitalk. Digitalk, the way to go.
Alternative Dig Talk. Real issues, real talk.
Hey Ugandans, I'm Lieutenant Colonel Dewa Kiki, the Deputy Defense Spokesperson, and actually the Deputy Spokesperson for the Uganda People's Defense Forces. I was hosted on Alternative Digitalk. I encourage all Ugandans that this is the way to go. Always watch, participate, give your views, and ask questions on Alternative Digitalk. Digitalk, the way to go.
Alternative Dig Talk. Real issues, real talk.
Okay, welcome back, our viewers. We are back with Professor George Wilson Kanyihamba, and he's going to take us through the reading of his latest publication. I should just say that the introduction much as it took long, but it was also equally relevant that he shares the preamble, so we know before we simply run into the book itself. I want to remind all our viewers that we are on social media page, the Alternative Uganda Facebook page. And also, please, he is here with us. You can call in on 0789017145 and ask him those tough questions in the event that you have any questions for him. With the questions about governance, don't mind. Ask him all these questions about the corruption in the judiciary and the rest. We shall be glad to receive you, and you ask him through our studio line 0789017145. Prof, let's proceed with page 5, where we have the title, "The Supreme Court is to inquire into and give findings and not hear or deliver judgment." Shall we proceed, please?
Article 104 of the Uganda Constitution 1995 provides headline: challenging a presidential election, and then I talk about the trouble with the Presidential Elections Act of 2005. Article Clause 1. Subject to the provisions of this article, any aggrieved candidate may petition the Supreme Court for an order that the candidate declared by the Electoral Commission elected the president was not validly elected. Clause 2. A petition under Clause 1 of this article shall be lodged in the Supreme Court, registry within 10 days after the declaration of the election results. Clause 3. The Supreme Court shall inquire into and determine the petition expeditiously and shall declare its findings not later than 30 days from the date the petition is filed. Where the petition is filed within the time prescribed under Clause 2 of this article, or where a petition having been declared, having been filed, is dismissed by the Supreme Court, the candidate declared elected shall conclusively be taken to have been duly elected as the president, as recently happened in the case of President Museveni. After due inquiry, under Clause 3, after due inquiry, under Article 3 of this article, the Supreme Court may, and it has choices, may A, dismiss the petition, B, declare which candidate was validly elected, or C, annul the election. Where the election is nullified, that's Clause 6, a fresh election shall be held within 20 days from the date of the annulment. Those are the provisions of the Constitution.
104.
And I want to say here, this will come later, but it's better to put it here, that the rules of interpretation which we use in Commonwealth countries, including Uganda, and which we inherited, and they are part of our law and the procedures, provides that the words, where the words are used in a constitution like this one, or in a legal document, are clear and unambiguous. The words I have read are clear and unambiguous. They shall be given, that is a mandatory, they shall be given their natural meaning. So the words used here, I want to repeat, are to inquire into and give findings. Bear that in mind. Now, under
Article 104 of the Constitution mandates.
Yes. Article 104 of the Constitution mandates and obliges the judges of the Supreme Court to inquire into a petition and give their findings within 30 days of the finding of that petition. Under the same article, the time in which to petition after the election and when the court is obliged to declare its findings, opinions, and orders is severely limited. There is a reason for this. The delegates recalling Uganda's history and that previous presidents, Milton Obote and General Idi Amin in particular, overstayed in power unconstitutionally. It is only in those circumstances when the Supreme Court can vary the fixed timetable that is provided in the Constitution. But cannot even only do so in accordance with the provisions of the Constitution. This is one of the articles in which nearly every judge of the Supreme Court has recommended should be amended so that they can extend the time, but this has not been done before. The Legal and Drafting Committee considered and debated the provisions of this article at some length. The Assembly itself, the Constituent Assembly, reconsidered and debated the same draft article, or rather clause, for many hours of their deliberations in the plenary sessions. We came to the conclusion, I was the chairman of the Legal and Drafting Committee and a elected delegate of Rubanda County. We came to the conclusion that in any petition, the petitioner, his or her witnesses, and the lawyers are likely to exaggerate just as their opponents, the respondents, their witnesses, and the lawyers are likely to deny or minimize the gravity of the illegalities and the wrongs committed in the elections. That is a fact of life, which we recognize in putting this article in the Constitution. It is under these facts and the circumstances that the NRM and its leadership coerced Parliament to accept the insertion of section 59, clause 6, paragraph A in the Presidential Elections Act of 2005. This is very, very important. And I should say a word about it. When Museveni's term was coming to an end, the term which he had been confirmed in 2001, the president and the NRM party diehards wanted him to stay in power beyond the constitution. So they persuaded the parliament to change the constitution. And the parliament refused. Then they managed in 2005 to enact the first amendment of that year, 2005, amending unconstitutionally the same constitution. But the members of parliament refused. The caucus members refused. Senior ministers, also including one who would have succeeded Museveni, Elia Kategaya, including other heavyweights like Bidan Sadi, like Amanya Mushega,
Miriam Matembe, John Kazora, and others.
Kazora, Miriam Matembe, they refused. Then the remaining MP, poor as Ugandans were each bribed with 5 million shillings. That was common knowledge and everybody knew in the news. So when these people accepted the money, the NRM leadership party corrupted, persuaded them to insert this clause. This clause is very, very dangerous. It is illegal. It is unconstitutional. And we have been complaining about it since 2001. And when we complain, the Attorney General of those days, they ignore our complaints. It's one of those I felt very strongly, even to give a dissenting opinion, that in the next presidential petition, if there is one, the court must reconsider. The court must consider this section, section 59, clause 6, paragraph A. This is the poison in the constitution that was administered by the corrupt leaders of NRM. And since then, my brothers and sisters, the Supreme Court has based its decision on presidential election petition on this section.
On an illegality already. On an illegality already.
On an illegality. This illegality is the one which guides the court. We shall come to it. And you see, these are learned people. These are patriotic Ugandans. All the judges, including the Chief Justice. How couldn't they see that this is an illegality? And they base their decision to uphold the election of the president and in illegality. How? I want every Ugandan, child, schoolboy or student of law or any other subject, voter, ordinary Ugandan Mukopi, ask the Supreme Court every time. What do you think about article, rather section 59, clause 6, paragraph A, which is not in the Constitution? It's not authorized in the Constitution. It was smuggled in after members of parliament were paid
5 million.
500, rather
5 million.
5 million shillings each. Can the 11th parliament sit tomorrow? And we are going to send them this booklet. I hope they will pay 20,000 because I was not facilitated to give free copies to everybody. Ask them. I want people who come from their constituencies. Every MP, whether you are NRM, NUP, ask your MP, have you got a copy of Kanyehamba's little book, which costs 20,000 shillings? And look at the page. I'll give you the page, 7, but we are discussing at page 7. And tell me, what do you think of it? Do you think our Supreme Court is right?
But Prof, as we move along, I will ask with your permission that I'll be interjecting.
That's right.
In your view, do you think there is will that these parliamentarians are even bothered at any certain point that such things, such illegalities should be handled with, with patriotism, or they are simply bothered about like someone has to care about their stomachs and
No man, you were the ambassadors. You the ordinary voter, you the ordinary student or schoolboy in your constituency. Whether they are bothered or not, you are bothered. Now you are bothered. Every journalist is now bothered. Every voter is now bothered. Every free-born Ugandan is now bothered. You ask them if they are not bothered. That question, you should put it to the MPs, not to me. I am bothered.
Shall we proceed with...
Okay, let's finish. Yes,
the 7th Parliament was bribed to insert. We can proceed from there.
Where is that?
After section 59.
Yes. The 7th Parliament was bribed to insert
ultra.
This ultra vires, meaning beyond the powers of the Constitution, as paragraph 6A, which clearly contradicts the provisions of Article 104 and Article 2, subsection 2 of the Constitution, which prescribes that the sovereignty belongs to the people. And it does not even appear in the Constitution as amended. It stands alone as a thief in the provisions of the Presidential Election Act
of 2005.
This is, as I said, the members of Parliament had already been compromised to delete term limits from the 1995 Constitution, which Lord Justice Alphonse Owine Doro was recently compelled to condemn as a wrong committed by Ugandans. Apart from being induced to approve paragraph 6A of Section 59 of the Presidential Elections Act 2005, members of that iniquitous parliament were enacting a law, were duped to think they were enacting a law intended to operationalize the 1995 Constitution. That's the same way the Parliament was induced to enact the Traditional and Cultural Leaders Act, thinking they were operating the Constitution, but that they gave themselves more powers and the government more powers than the Constitution allowed. It was also, they were duped. And so we are saying that
after members of parliament had
received a bribe, they were persuaded to debate time limits from the Constitution at the time that is when the NRM party leadership smuggled and inserted in the section, rather section 59, clause 6, paragraph A, into the Presidential Elections Act of 2015 and 5, yet they were aware that a similar provision had been flatly rejected in the plenary sessions of the Constituent Assembly while the Constitution was being made. For this reason, the Uganda Constitution text, even as amended several times, does not today contain this in any similar provision. It is important to note that the Constitution did not give jurisdiction to the Supreme Court to mathematically value or weigh the legalities and the wrongs committed in any election, or decide to whether those wrongs were substantial or not to affect the result. The findings and the reasons given on the 20 and 11 and the 20 and the 6 presidential election petitions should be regarded as binding precedents in any subsequent petitions. But as we'll see later, they have always been ignored.
I want to ask you a question on behalf of our viewers, Prof. That it's on record that in 2001, is much as the law provided and still provides for, it provided for at least 7 Supreme Court justices to preside over a presidential elections petition. At a time, your colleagues were 6, and later alone 5 to hear Bessege's petition. Wasn't that an illegality?
It was an illegality. I was already a member of the Supreme Court, but I was, depending on appointment, I was what they call the youngest member of the court, not necessarily by age. And therefore, actually, Justice Kalokola, who was not very well, had said, I will stand down for Kanyeihamba so that it is 5, because you have to be 5 in any given case, but not a constitutional case. Because the 2001 and rather the 20, our constitution, 5 years before, is it? 10 years before? When did we make the constitution?
1995.
1995. Had provided that the minimum number of judges to be there to
Here,
decide
petition,
a constitutional matter
Should be.
is 7.
Yeah.
But I will not go into details of what happened. But by the time we were fixed to hear the 2006 constitution, rather, when 2001
yeah.
petition, we were only 6 judges. But 6 we couldn't sit because if we
even
divided,
number,
because we
yeah.
were all equal, there would be
A likely of
no,
a draw.
there would be no division. So the Chief Justice, in his wisdom, Justice Odochi said, we shall only be 5. To hear this matter is very, very important. So Kanyeihamba, being the juniorest of all of us, will stand down. So I did not participate in the panel discussions or decision of 2001. But of course,
It was an illegality.
yes, being a constitutional lawyer, they consulted me from time to time. They were unanimous that the election had not been free or fair. They were unanimous that rigging had taken place. They were unanimous in all the questions they asked themselves, because they discussed with me. Then it came. Your decision is to be made under the heinous and illegal provision at rather section 59, clause 6, paragraph A. So they said, notwithstanding your findings, there were so many illegalities that there were many unconstitutional matters made. They didn't make any difference to the final result. And the answer there is not legal. That answer is not founded in justice. It is your personal opinion, which NRM wanted it.
It's a political answer.
Yeah. So they are asking you, despite what wrongs Museveni did in the election, despite that what is Chigundu ignored all the rules and was bribed, did it make any difference to the result? And when you like Museveni, as we all do, but some of us differ on the law, then you say, the candidate is Museveni. Museveni is a nice man. And therefore, it didn't make any difference to the result because we still want him as a president. You are making a political decision,
not a legal decision.
Not a legal decision. I asked them, I was there with the late Sekoko. Unfortunately, my other witnesses like Sekoko, like Jasodale, are no longer with us. God recalled them earlier. But if they were here, they will confirm I would be with them here. So Sekoko and I, Odell was not there, we asked our colleagues. But supposing Amin was still president, and he's the one who had won and made all these unconstitutional decisions and behaved the way he's doing, and his military personnel went around beating everybody, supporting imprisoning voters. What would be your decision? They were unanimous. We were all unanimous. No, in that case, we would nullify the election and order another one, hoping the losing candidate, if it at that time was Semogere or Bote, would be elected. So that I want people in the schools and headmasters to sing this article, rather this section. Section 59, subsection 6, paragraph A, is an iniquity. It is unconstitutional. should be deleted from the laws of Uganda with immediate effect, because it is there as a temptation, as the fruit in the Bible tempted Adam. As the lady in Israel attempted Samson. This paragraph is dangerous to our democracy. This paragraph A is enigma to the laws of Uganda. This is the only paragraph that has justified all the victories of President Museveni since 2001.
Regardless of the irregularities.
That's right.
I want to ask you before we proceed, Prof. Viewers might be interested in knowing what could have happened had the petitioners withdrawn from the proceedings, quoting and citing the law, because it was providing it is supposed to be 7, and this time round you people were 5. So the proceedings, in my view, and just like any other person's view, were deemed an illegality. But you people, your colleagues, continued and had the petition, even when at heart they knew that they were less the number that is required by law.
Yes, I knew. And I raised the matter on several times, including when I wasn't on the court itself, 2001. The Chief Justice, on the first occasion and the second occasion, was none other than Odochi. Odochi is a constitutional lawyer, if not in certain practice. He's one who marshaled all the evidence to put in the draft constitution to be debated in the Constituent Assembly. He was there. The legal committee which made the constitution was composed of 15, not 1 or 2, not Kanyihamba only, 15 lawyers, eminent lawyers. We named them, some of them in this book. They had debated a similar provision, and it is to be found if you do research in the massive volume containing all the proceedings of the Constituent Assembly. Then, in the 2006 election, I am the only one, Kanyeihamba, who insisted and read my findings and the suggested order. And I start my findings with G.W. Kanyehamba's inquired into the Constitution. And the following are my findings. Only, I believe the other one was Sekoko. The others called them, they had the petition. And this is their judgment. Where did they get the word judgment? I want to ask you, all those who are still alive. Katu Devi, I think, is about the only one still alive. Others have been recalled. I think God has kept me going to be a witness and to write this little book. I hope it will be always available to petitioners, their parties, and the people they are representing, and the respondent, so that anybody can say, Kanyeihamba, whether I'm still alive or not, said this. Is he wrong? Or are you the one who is right? Because what I have written is purely factual and exactly what happened. It's not an opinion. It's just a narrative of the truth.
I don't want to assume that you are avoiding my question.
I will answer it.
Yes, I'm going back to 2001. Why did your colleagues proceed when they knew that there were 5 than the required number of 7 as provided by law?
Their view, if I can remember the exchanges we had, was that the Chief Justice, and I am witness to him, had written to the President to make the court 7 judges, and the President either ignored or did not respond or communicate his response to the letter. I remember vividly there was also a challenge of the referendum result. On that occasion, I was a member of the panel, rather I was a member of the court, and the Chief Justice gave notice that the case will be heard on such and such a day. We were only 6. The Chief Justice, Katulebe, wrote and read to us the contents of the letter to the President that we are going to be hearing the referendum case on such and such a day, and that the Constitution requires to be 7. We are requesting you, Your Excellency, to appoint. I don't know whether the President ever consulted the Judicial Service Commission. Because also, to be fair to the President, a judge, a nominee must be nominated by the Judicial Service Commission. Whether it is a judge of the Supreme Court, any other court, or Chief Justice, the nomination must come from the Judicial Service Commission. Presumably it is a question of which came first, the egg or the chicken. Because then the President, the Judicial Service Commission might continue saying, we never told them. But the Chief Justice, Odochi, had I been, I don't know what he did, in writing to the President, he should give a copy to the Judicial Service Commission, to the chairman, and say, we need very badly a new judge of the Supreme Court. So what I am saying now, I remember, and I can answer your question. The Chief Justice, Justice Ben Odochi, had written, and he showed us the letter, to the President to appoint another person so that we are 7. His letter was ignored, or if he received a response, we don't know what that response is. But I will tell you, at one time, Chief Justice Odochi went abroad on duty, on some function. And the late Deputy Chief Justice, Chikonyogo Mukasa, acted as president because she was Deputy Chief Justice. She also wrote, we urged her that we don't have a 7th member, kindly remind the President to appoint one. It seems that she also, fortunately again, she has left this world. She could be our witness. And it seems her letter was equally ignored. Now, to be very fair to our Chief Justice, Odochi, when he came back, the case on the referendum was very eminent. So he will call, I am going to call the president. We have no time to constitute that, but I am going to call that court. So he called the court to order. We turned up in the court. At that time, the court's premises were in Mengo, occupying the former Buganda Kingdom judicial premises. I remember we sat 6, and the chief just told them, we can't hear this case. That was another case. We can't hear this case because we lack a quorum. But it was not the referendum, because I remember the referendum, eventually we had a quorum. I can't recall correctly, but I think we got somebody to join us from the Court of Appeal. And we became 7, and then decided the referendum case. But after the referendum had taken place, and if I remember, I gave the lead judgment, and we justified that all actions taken after the referendum were valid because the referendum had been held under the provisions not of the illegal act, but under the Constitution. I remember that. Then it is after that case that the president appointed an additional member of the Supreme Court, and we became 7, and that was Justice Bart Katurebe, who joined us as our junior. And that is why in 2006, we were able to form a quorum of 7 with Katurebe with us, and made a constitutional valid decision of that year. So you are quite right that the quorum in 2001 was decided by a court without a quorum, but the lawyers, our lawyers, I tell you, no lawyer objected. And if lawyers don't object, the judges cannot do it themselves. So you have to forgive that, forgive us in 2001 that no colleague of mine on the panel, I wasn't there, raised the issue personally. Okay.
Prof, one last question regards to the same. Would you act differently? Suppose, had you been the Chief Justice, would you act differently?
Yes.
Would you proceed with
because you see, under the Constitution, the president, rather the Chief Justice, is the chief administrator and the head of the judiciary. So you ask the president to replace a judge in Supreme Court. But the Chief Justice has the power to deploy judges of all of the courts in some function. So had I been the Chief Justice, but I must also confess, I didn't advise the Chief Justice to do so. So I am also at fault. I didn't. But had I been Chief Justice, I would have done my level best to plead with the president, even to appeal to the Speaker of Parliament that we need another judge, because if that case is not been, if it is not heard, Uganda will be in bad light internationally and otherwise. But as I say, I didn't give this advice also. Although I was the juniorist at that particular time of the judge, nevertheless, I was respected and actually feared because they thought I was a personal nominee, which in many cases I was, of President Museveni to be a judge.
Okay, we shall proceed in the next 10 minutes before we close our morning today's episode. Prof, shall you please proceed?
Where was I?
Page 9, the first sentence of Constitution. Then, as the best Ugandan have ever made, and he said that he would go back to the
This was page what?
page 9. Yeah, it's up here.
Mm-hmm. Is this for several years? That's where we start.
Yes.
For several years, the Constitution continued to be strictly adhered to, and the country governed well under it. It was not long before, however, that Uganda and the rest of the world discovered that the NRM, which had been popular
For mobilizing.
mobilizing and developing the country collectively and popularly, was slowly being dismantled by the NRM leadership, which desired to establish a permanent authoritarian regime with its leader, President Museveni, wallowing in absolute power and the glory of being the most decisive, dominant force and the voice governing Uganda and her people. Subsequently, the NRM and Museveni's wishes overruled the aspirations of the people of Uganda they had entrenched in the Constitution. To sustain the culture of misgovernance, the NRM began to mislead and indoctrinate Ugandans that political parties of any description were enemies of the people and its development of the people and its development. As one leader of the former Soviet Union once said, if you repeat a lie many times and inflict fear amongst the people, they will begin to believe the lie.
We shall, for now, I will ask you a few questions, and this will mark our episode 1 because we have 5 minutes to the close of the show, to 9. I would want to ask from you, with this background, because now the preamble is clear, what makes your learned colleagues blindfold their eyes and avoid the words like inquiry and findings? Is it out of fear?
I have no evidence whatsoever. They have been, there's an either that any of them have been bribed. But I have been close to Museveni for a long, long time. I don't fear him. I respect him as my president. He has helped me many times. And I regard him not as a dangerous and killer president. But I have discovered that many Ugandans are frightened of him. They are afraid that if they do anything which is correct, but is against his wishes, they will be killed. There is that feeling, I don't know why. I have no reason to think that he is like that. But there is that feeling. Because, as I will tell later, maybe after I have read my question, or as you ask me questions as we go along in the next episode, one of them, when I said, why have you changed your mind? He gave rational reasons which were not acceptable. But later, before his death, and God is my witness, I'm not defaming him or putting words in his mouth. He said, George, we were very close. Knowing where I come from, would I have voted against Museveni and lived? I want you to remember that. Many Ugandans are frightened of the movement. They were frightened of Kayihura, who calls me uncle. And when I tell you, Kayihura really respects and loves me, because I was very close to his maternal uncle, the late Justice Mulenga, who was my best man at my wedding, and I was his when he married his first late wife. But people were very frightened of Kayihura. When recently they took me into a safe house, the police, and I know who they are. They imprisoned me in my wheelchair. At one time they arrested me in my wheelchair. It was on social media, but the Uganda press, New Vision, and the Monitor. I was a regular columnist for 10 years. I own shares as the original shareholder in the New Vision. They were silent. One of their columnists of Monitor, he's frightened. I think you know privacy, his name. He wrote a review of my book, Kanyeihamba the Incredible. And he handed it over to them. They said, no, Kanyeihamba is a no-go area. We don't want his name to be mentioned here. You remember many of them came to the launch of my book, Constitutional Government or whatever, a public law and government. Not a single article has appeared in New Vision or Monitor. I know many journalists there working there. I even called. One of them said, I am coming to the launch. A journalist I admire wrote from NBS. I sent him an advance copy and said, I will come to the launch. I write a story about it. She never came. She's never responded. I have sent all of them a copy of this book. None has acknowledged the receipt of them. None will admit to their bosses that they are friends of mine.
Okay.
That is the reason. Why is there endemic political and personal fear among the Ugandans? It is terrible.
Okay, viewers, my name is Tumuhimbise. I've been with Professor George Wilson Kanyihamba, and I can assure you, by God's grace, we shall be with him in the second episode this week, Thursday, same time, same social media page, The Alternative Uganda. On YouTube, we are The Alternative Uganda. Then Twitter is Alternative Uga. Do not forget to send in your comments and questions so that by the time we come back on our next episode, we already have your questions in advance. But also say, those of us that haven't read or bought his previously launched book, Evolution of Constitutional Law, Public Law and Government by Professor George Wilson Kanyihamba, on my right. That book is in all leading bookshops at only 100,000 Ugandan currency. Over 700 pages of brains, of wisdom and of knowledge. Do not miss grabbing yourselves copies, but also so many other publications from Professor George Wilson Kanyihamba. All those books are in all the leading bookshops. And to also add, as we prepare to leave here, this latest one, challenging a presidential election, Article 104 of the Uganda Constitution and the Presidential Elections Act, will be in bookshops as soon as this week. This week. May God bless all of us, bless you all for God and my country, as we look forward to waiting for the results from Kololo. Is it Kadaga, Mwana Waife? Is it Jacobo, Olanya? Why not? Keeping up with us, the Alternative Digital. May God bless all of us. Thank you.
Alternative Dig Talk. Real issues, real talk.